सेव किया था ना?
मैं सिर्फ इसलिए गया था क्योंकि उसने मुझे कॉल किया, that's it. But listen तो.
Save it for someone else.
जिंदगी में सेव करना जरूरी है, मगर जब बात पैसों की हो, सिर्फ सेविंग से काम नहीं चलेगा। इक्विटी म्यूचुअल फंड्स में इन्वेस्ट कीजिए और अपने सेविंग्स को आगे बढ़ने का मौका दीजिए।
Mutual fund investments are subject to market risks. Read all scheme-related documents carefully.
For our national interest column this week, here is a proposition for debate. Over the past 15 years or so, our judiciary, from the trial court level up to the Supreme Court of India, has progressed, if you can call it progress, from a reformative institution to a retributive one. That is the proposition I am offering for debate. We aren't just basing this on the fact that 2002 was the year when India's trial courts awarded 165 death sentences, the most in a single year since 2000. In fact, it seems that it's the highest ever, but it's difficult to fully, firmly establish that because data before 2000 is not easily available. The National Law University has been compiling data, and what we have authentically available is since 2000. We aren't even basing it only on the fact that this has taken the number of convicts on death row in India to 539. As a well-researched but disturbing story by Apurva Mandhani showed, this is the highest in 17 years. I will share a link of the story with you in the description of this video. Now we know that most of these will be commuted and some acquitted. All of 8 convicts have been hanged in India since 2000 in 22 plus years. 4 of these for the Nirbhaya gang rape murder alone. That makes for half of all those executed in India in the past 22 years and 3 months, and yet we have 539 right now on the death row. Why then have our trial courts been so happy to pull the judicial trigger? Because they know that ultimately hardly anybody will actually be executed. Let's jump now from trial courts across the country to the top court. Read this rising wave of angry death sentences with the Supreme Court's latest order, sort of reinserting what it had read down in 2011 in the already draconian Unlawful Activities Prevention Act, or UAPA. The 3-judge bench of Justices M.R. Shah, C.T. Kumar and Sanjay Karol overruled the 3 earlier SC judgments that strengthened the principle that mere membership of a banned organization was not an offence under UAPA. That, to be charged under the law, the alleged member should also be someone who has overtly participated in an activity organized by the banned organization. The latest 3-judge judgment has fully read it down and effectively empowered the police or probe agencies to pick up anybody on mere suspicion of being a member of a banned organization. And once an individual is arrested on this mere suspicion of membership, he or she will be hit by the full force of the UAPA, a law so tough it reverses the burden of proof onto the accused and makes bail nearly impossible. This is guilt by mere suspicion of association. Reversing the burden of evidence means that the principle of innocent until proven guilty does not apply. It's exactly the opposite. Guilty as charged until you can convince the judges of the contrary. The regrettable fact is this isn't an isolated case. Over the past several years, we have seen the top court lean in the same direction. Several laws, especially some of the tougher laws in the larger UAPA category, have been further strengthened instead of being made fairer to the defendant, as may have been the expectation, or at least the liberal expectation, because the top court takes pride in standing up for the liberal principle, or the North Star, as the current Chief Justice quite rightly describes it. How does this principle view then square with not just the latest UAPA judgment, but also what the same court, under various eminent judges lately, has done to make the Foreign Contribution Regulation Act, FCRA, and the PMLA, Prevention of Money Laundering Act, even more draconian in the hands of the state, making bail even tougher? See some specific cases. The Delhi High Court struck a blow for liberty on UAPA while granting bail to Devangana Kalita, Natasha Narwal and Asif Iqbal Tanha in the Delhi anti-CAA protests. Justices Siddharth Mridul and Anup J. Bhambani had ruled that UAPA could only be invoked for what can be sharply defined as a terror act. Sharply defined as a terror act. not mere suspicion association. The bench cautioned against the cavalier use of the phrase quote-unquote terrorist act, saying that the definition was wide and somewhat vague. The Delhi police rushed to the Supreme Court, which mercifully did not interfere with the bail orders but stayed the operation of the judgment. The implication is that while those arrested or the applicants will get their bail, the judgment cannot be cited as a precedent in other similar cases to say that, look, this High Court judgment has read down UAPA. In July 2022, a two-judge bench led by Justice A.M. Khanvilkar set a new judicial principle by finding a petitioner in a PIL, finding a petitioner seeking a CBI probe into a massacre of tribals in Dantewada, which he alleged was a case of extrajudicial killings. The court accepted the police version that the killings were carried out by Naxals. It not only fined the petitioner, Himanshu Kumar, but also accepted the centre's demand to let its agencies investigate the petitioners instead. It added that, and I quote, the investigation may not be limited to charges of creating false evidence, but may also involve charges of criminal conspiracy of any offense or any offense under Indian Penal Code. We can go further back still. In 2016, a bench headed by Justice Ranjan Gogoi, not CJI yet, gave another remarkable order that erased the distinction between PSU, that is government owned, and private banks in at least one critical manner. Along with Justice PC Pant, Gogoi expanded the definition of public servants under the Prevention of Corruption Act. It held that all officials of a private bank operating under the RBI's license would be treated as government servants. Accordingly, they expanded the state and the CBI's jurisdiction to what was until then purely private businesses. Every now and then, like the Delhi High Court orders in the UAPA bail case, you find a whiff of fresh air from a court, like the judgment by the bench of Justices Pankaj Bhandari and Sameer Jain of the Rajasthan High Court earlier this week, which sparked this week's national interest. They freed 4 convicts on death row in the case of the Jaipur serial bombings that killed 71 and injured many more in May 2008. The 4 had already spent more than 15 years on death row in jail. All were picked up following the Batla House encounter in Delhi and suspected to be members of another module of the Indian Mujahideen, quote-unquote Indian Mujahideen, which claimed the Jaipur bombings. This is a classic example. And I quote from the judgment of the Rajasthan judges, Rajasthan bench, this is a classic example of institutional failure resulting in botched/flawed/shoddy investigation. This was the acquittal order, from the acquittal order. The injustices these 4 suffered obviously shook the conscience of the judges, who also made a reference to the 2006 Supreme Court judgment in the famous Prakash Singh case. Prakash Singh ji, by the way, is a veteran cop who has been fighting for police reform for a very long time. The judges invoked the Prakash Singh case to underline the imperative of setting up a police complaints authority primarily to deal with such gross shoddiness and grave injustice. Rajasthan High Court is a stirring order. And while this brilliant judgment is celebrated, remember which is the law that enabled these policemen not only to get away with these excesses but also secure conviction in all 4 trial courts. No surprise that it was UAPA, where, as we just explained to you, the burden of evidence lies on the accused and not on the prosecution. This precisely is the law that has just been strengthened by the Supreme Court. Both contradictory orders from the Rajasthan High Court underlining the perils of misuse of this draconian law, and from the Supreme Court strengthening it further, have come within the same week. It is always a challenge to see a trend in the Indian judiciary and to then find evidence to establish it. One important reason is that the top judges, especially the Chief Justices of India, have short tenures. This is unlike the top civil service and armed forces positions as the key leadership of other institutions, Election Commission of India, CAG, SEBI, CCI, Competition Commission of India, because they have fixed tenures. Second, because they make their own appointments, you can't directly link it to changes in the elected governments and ideological regimes as you might do, say, in the US. And third, because neither do our judges have a clear career track, unlike our civil servants, nor do they need to face frequent evaluation by any voters or constituents. The only way we can assess and evaluate them is through their judgments, neither public speeches nor obiter dicta. The evidence lately, regrettably, is a distinct evolution from the doctrine of reformation to retribution. And finally, before I conclude, let me also thank Bhadra Sinha, who's our editor for legal affairs, for helping me in writing this article.